Well, welcome everyone. I'd like to welcome on behalf of Brinks Hofer, the CITCA, our other guests. We're excited to be able to present our topic today, which is using U.S. trade and competition laws to protect brand names. And our program is going to be based on a hypothetical case study, which is on your tables, or if you're watching remotely, it should be available by email to you already. Also, if you're watching remotely, you'll be able to send in questions using the chat function. Otherwise, if you're sitting here today, feel free to speak up. We've got a mic if you'd like to ask questions and let everyone hear. The benefit of hearing your questions would be greatly appreciated. So let me try to keep introductions brief because we've got a lot of material to cover today. My name's Laura Miller. I am a litigation partner here at the firm. I'm also the chair of the International Trade Practice Group. Our panel of experts today includes Nick Delatorre to my left. He's a partner at Brinks. He is responsible for counseling and assisting clients with trademark and unfair competition disputes, both in federal district court as well as customs and the USPTO. To Nick's left is Dave Fleming, another partner at the firm who focuses primarily on litigation but also does counseling of multinational companies. He's the chair of our trade practice group. And you'll hear today he's also quite knowledgeable about social media and other internet-based trademark issues that are coming to the forefront these days. And then our final panelist member is Carl Charneski. And Carl joined our firm earlier this year. We're very honored to have him as a member of the firm. He was for years an administrative law judge, most recently at the U.S. International Trade Commission, or the ITC, as you may have heard it referred to. So for today's presentation, we've picked a little bit different format. What I'd like you to do is pretend that you are the board of directors of the company Hero Power. And this panel of experts has appeared to the board today to advise you on trademark and unfair competition issues, because your company, Hero Power, is an Egyptian company, very successful in wind turbine technology and alternative energy. It started out in the Middle East and in Europe, has manufacturing facilities primarily abroad. It has been involved in a joint venture for a number of years here in the U.S., but is now starting to import product into the U.S. as well. And the products have been, as you can imagine, particularly here in the Midwest, extremely successful. With that success, there have come competition. That competition is not just on the technology front, but also on the trademark and trade dress front. And what our experts will talk about and advise you today is whether or not your trademarks, Hero Power and Midwest Hero, which is the name of the joint venture, and the logos and your company's trade dress, whether or not that's protectable under U.S. law, and whether or not the competition's use of marks such as Wind Hero, their logo, Wind Hero, and their trade dress is unfairly competing in the marketplace against your company. So with that little brief introduction, we'll start with Dave Fleming, who will give you a background on the trademark principles that are at issue today.
Thank you, Laura. When I talk to management groups or boards of directors about trademark issues they have, one of the first things I ask is how many people know anything about trademark law. So I'm going to ask this board, nobody from Brinks, people who are not from Brinks, how many of you have some experience with trademark issues? One or two, a few do. Oh, quite a few of you do. Well, what I'm going to do is set the stage or provide a framework talking about the trademark law principles applicable in the United States to this issue. And then Nick will cover ways that you could enforce your rights in hero power and in your trade dress through Customs and Border Protection and through the federal courts. And then Carl's going to discuss how you would deal with those issues if it's possible in the International Trade Commission. So here are the topics I'm going to go through pretty quickly today. First is talking about what trademarks are and how they're created and how they relate to other types of IP, the importance of likelihood of confusion in U.S. law, as is the case in the law in other jurisdictions as well. I'm going to talk briefly about trademarks and internet and social media issues. Those aren't specifically involved in the problem we have here today, but they're very significant issues for every trademark owner in the United States and throughout the world. And so it's important to be aware of recent developments, at least in the U.S., on those topics. And then I will talk a bit about the fact pattern that we have and the kinds of trademark issues that we would be focusing on in litigation in federal court or in litigation in the International Trade Commission. And then you'll hear from Carl, there will be additional issues that are relevant to ITC cases that aren't relevant to federal district court litigation. So first, what are trademarks? You probably know. Common examples, it can be a word or words, a logo, a slogan. It could be a color. It could be trade dress, which we will have here present in this case. The key is that whatever that symbol is, whether it's a word or whether it's a logo or one of these other devices, is that it needs to be recognized by relevant consumers as identifying the source of product. Consumers don't need to know who that source is, but they have to have an understanding that the trademark represents a product that comes from a particular source. And one of the functions, especially in U.S. law, of a trademark is to assure that a consumer who purchases a product, and it can be a simple purchase of a consumer good to very expensive products like we would have involved in this case, wind turbines, they need to know that the trademark functions as assuring a certain and expected level of quality. And the rights in the trademark are created in the United States through consistent use of that mark as a trademark. Other types of IP that we're not dealing with in this presentation include, of course, patents, which protect inventions, copyrights, which are used to protect literary and artistic and other works, also trade secrets, protecting proprietary information like the Coca-Cola formula, and rights of publicity, which protect rights of individuals in their name, their image, and in their identity, and that they have the right to make commercial exploitation of those rights in their name, image, and identity. So, how are trademark rights created, and how are they enforced in the United States? What's most important for creation of rights in the U.S. is that a mark has to be used consistently as a trademark in order to be recognized and protected as a trademark. Registration in the United States can be helpful. It can make it easier to protect a trademark, but it's not necessary in order to create a trademark. And what's very important is that use is required in order to maintain rights in the trademark, whether or not it's a registered trademark. Then what does a company need to do to enforce its rights in a trademark? It needs to show first that it has a protectable trademark. It's a valid trademark, something that can function as a trademark. It mustn't be a generic term. It mustn't be a merely descriptive term that hasn't acquired another meaning among consumers as reflecting a trademark. Second, you have to show that you have priority in your rights in that trademark over others, over the junior user, over the defendant normally. And then you have to show, if it's an infringement case, you have to show that there's a likelihood of confusion. And I'll explain that a little bit more as I go into this. There are other kinds of claims. For example, there's something called a dilution claim in the United States, which is a concept that's used to protect famous marks. It's not necessary to show that there's infringement in the case of dilution. What you have to show, though, is that that mark is recognized as a famous mark in the United States. I'm going to focus mainly today on infringement and likelihood of confusion because that's the typical and usually the most common battlefront for a trademark issue. So, likelihood of confusion, that's really the touchstone of an infringement case in the United States. It's always an important factor in a case involving infringement, and there can be different types of confusion. There can be confusion about the source of the product. The consumer may believe that a product, because of the confusion, is coming from the defendant rather than coming from the plaintiff. Or there can be a reverse confusion where the understanding of a plaintiff's mark is overwhelmed by a junior user that is so large that consumers then begin to believe that the products with that mark come from that senior user that junior user who's much larger. But there are other kinds of confusion that can be relevant too, even if consumers understand that the products at issue don't come from the same company. They may believe that there is some affiliation between the companies or some kind of sponsorship, or they may believe that there's been some kind of endorsement of the defendant's goods by the plaintiff. These are also actionable types of confusion in the United States. So in deciding whether or not there is a likelihood of confusion, to look at our fact situation, to decide whether there's a likelihood of confusion between the hero power and win power word marks, or between the trade dresses that are involved, and that we'll look at in a little more detail in a minute. Courts consider a variety of factors. The specific factors they consider may differ depending on where your case is pending in the United States, but they're basically these factors. First, courts look at similarities. Are there similarities between the marks, between the goods, or if there are services involved, between the goods and services provided by the two parties? Are there similarities in consumers, in their markets, their target markets? Are there similarities in the channels of trade, in the manners in which they sell product, reach consumers for their product? Next, the court will look at the strength of the plaintiff's mark. In this case, we've got some word marks: hero power, Midwest Hero. Then we also have a logo. It was the hero power with the image of blades, and then we've got claimed trade dress in the color of the blades that are included on the wind turbine, and in this case they're sky blue wind blades. So are these strong marks? How will a court decide that? If a court's looking at word marks, they will look at marks on a spectrum from the strongest to the weakest. The strongest terms are terms that are arbitrary or fanciful. Google, many believe, is an arbitrary term, a fanciful term. An arbitrary term is taking a term like apple that has a normal generic meaning as a kind of fruit, but then it also has a meaning, a trademark meaning, as a very popular type of computer or iPad or iPhone or other device. There may be terms that are suggestive. They aren't fanciful or arbitrary, but they aren't merely descriptive either. Then there may be terms that are descriptive. And a merely descriptive term normally can't be protected unless that term also has, through extensive marketing and sales by the plaintiff, unless that term has come to be recognized by consumers as being a trademark. A generic term, a term like if you were talking about an Apple computer, the term computer is generic and it can't be protected. There can be terms that were once protected as trademarks but are no longer trademarks because they become generic. In the United States, a famous example is the term thermos, which was once a trademark for an insulated bottle for holding cold or hot liquids, but because of frequent use in the marketplace, the term and the failure of the owner of that mark to protect it as a trademark, that term was found to be a generic term. So even a term that starts as a trademark, if the trademark owner isn't careful about the use of that term by consumers, can become a generic term. Then another factor, after the strength of the mark, that courts will look to is how sophisticated consumers are for the products at issue and how much care they're going to exercise, the degree of care they're going to exercise in deciding whether or not to purchase a product. The more sophisticated the consumers, the more care they exercise in deciding whether or not to purchase a product, the less likely it is, at least this factor would suggest the less likely it is that there's going to be confusion between the plaintiffs' and defendants' marks. Now in this situation where we're dealing with very expensive products, wind turbines, you can expect that the sophistication is going to be very high. The degree of care taken by purchasers, in this case it would be power companies for example, will be very high as well. But even in those circumstances, even in cases where the degree of sophistication and the degree of care is high, courts have still found that confusion can be possible, particularly if courts are looking at confusion like endorsement or as to affiliation. Then another factor courts look to is whether or not there has been any actual confusion between the parties' goods. It's not required to show that there's actual confusion in order to make a case for likelihood of confusion, but it's helpful if you've got examples of actual confusion. A substitute for actual confusion that's often used is a consumer survey. And in trademark cases, there very often are consumer surveys by both parties showing that there is or that there isn't a likelihood of confusion. There may be surveys on other issues in the case. For example, if it's a more descriptive mark, and the question is whether the plaintiff's mark has acquired another meaning, a trademark meaning, what we call secondary meaning. There may be a survey on that. If you had a dilution case and you were making the argument that your mark is a famous mark, there might be surveys on that issue. So surveys are often very important in these cases, particularly in likelihood of confusion cases on the question of whether or not there is likely to be confusion between the marks. And then another factor courts look to is the intent of the defendant. What did the defendant know of the plaintiff's mark at the time it decided to use its mark? The idea would be that if you can show an intent to trade on the goodwill, if you can at least show awareness of the plaintiff's mark, courts may find that that is a factor that suggests that it's likely the defendant understood that they would be able to trade on the goodwill that the plaintiff has created in its mark by choosing a mark that is likely to be confused. So the intent often is a relevant factor. Now, before I go to these kinds of principles as they would be applied in this case, let me talk just for a minute about internet and social media issues. As I mentioned, this case, at least in the facts we've presented, doesn't involve these kinds of internet issues, but these are becoming very important issues in litigation in the United States. They're very important in Europe. I know there was a recent decision by the European Court of Justice involving eBay. There was another one involving Google and keyword advertising. These internet issues are becoming very important in the trademark world, not just in the United States. The first hot topic that you often see is the one that I mentioned already, keyword advertising. The use of somebody else's trademark in order to cause your ad to appear when somebody enters that trademark in a search engine, whether it's Google or Bing or Yahoo or another search engine. And these trademark advertising issues, keyword advertising issues, are appearing not just on the major search engines now, but also on social media sites. Facebook and other sites allow those who are, for example, on eBay or Amazon, if you're advertising product, you're selling, say, for example, iTunes products. Say you're selling an iPhone. You may put iPhone in as a keyword on Facebook or on eBay or on Amazon as a way to lead people to your site where you can purchase those products. So keyword advertising is an issue in social media sites, not just on search engines now. And then social media raises other issues as well. There can be use of trademarks in profile names, whether it's a Facebook or other profile, a Twitter profile, on Facebook or other social media site pages. An area that's becoming much more important now is that there is use of trademarks in applications. An iPhone or iPad app that you purchase through iTunes, or an Android phone app that you purchase through the Android marketplace. There's frequent use of trademarks both as keywords in those application finders and then also in the applications themselves, leading to a likelihood of confusion at least about endorsement or sponsorship, if not also about source. There are issues involving impersonation. Those are normally right of publicity kinds of issues for an individual who's being impersonated on Twitter, but companies also are impersonated on Twitter as well, so those become trademark and not just right of publicity issues on Twitter. And then I mentioned sales on sites like eBay or Amazon. The issue there is often the sale of counterfeit goods. There was a very important decision in the United States last year in the federal appellate court in New York involving eBay and counterfeit sales and whether or not eBay could be held liable on a secondary basis for the sales of counterfeit goods on eBay. And the court held that eBay could not be secondarily liable because it did not have actual knowledge of all the cases where counterfeit goods were being sold, and it was taking steps in order to try to locate and prevent the sale of counterfeit goods on the site. And there have been similar kinds of cases involving these issues in Europe, in the European Court of Justice. So all of these social media issues, particularly so far the counterfeit issues, are issues that are relevant throughout the world in the trademark context. One other point to note about hot issues in the internet, probably the biggest issue that trademark owners are going to be dealing with, is the expansion of top-level domains by ICANN. This is going to be taking effect beginning in January. Companies will be permitted to apply for the right to own a top-level domain. Top-level domains are domain names, like everything after the dot in a domain name, like .com, .gov, .edu, .info. Those are called top-level domains. And right now, there's a limited number of top-level domains. So to this point, if there have been issues involving domain names, it's been the content to the left side of the dot that people have fought about. You know, for example, if I'm Apple Computer and somebody had been able to register the domain name apple.com, there would be an obvious trademark issue with that, and there are mechanisms in place for resolving those kinds of disputes. Well, now the disputes are going to move to the other side of that dot, because anyone is going to be able to register a generic term or a brand term after the dot. For example, using Apple again as the example, a generic term, a generic top-level domain could be content, whatever the content is before the dot, but then it would be .computer. So if Apple is able to register .computer, they are going to have advantages probably over other computer companies, because people going to .computer are going to reach Apple sites first. And then it also will be possible to register a brand term after the dot. So .apple might be registered. You can expect that the computer company will be trying to register that term, but there may be others, like an Apple Growers Association in Washington State might want to get .apple. Now, this expansion of ICANN domain names is going to be a very important issue, but the price of admission for someone to buy one of these is going to be much higher than it's been just to buy a .com domain name. At the starting point, just to apply, you have to pay $185,000 to ICANN in order to get the process started of registering this new top-level domain. And then there will be other costs along the way. You're going to have to show the ability to function as a registry, that you'll be able to act as a registry. And if there are disputes, take for example, say there's a dispute between Apple Computer and an Apple Growers Association over wanting to get .apple. There will be an auction process for resolving who is the party that's going to get that new top-level domain. And that, you can expect, is going to be a very expensive process in some cases. There's a lot more information on this ICANN expansion and on what the procedures are going to be for registering these new top-level domain names. Just let us know if you'd like more of that information, and we can point you in the direction of some of the resources available on ICANN, and we can provide you with our own materials that we've put together involving this expansion of top-level domains. But as I said, this case doesn't really involve internet issues or social media issues. What are the issues that this fact pattern raises? Well, let's first identify what the trademarks are, and if you have that sheet, that's an easy way for me to identify them. It's the second page of that handout. Obviously, there are word marks involved. For Hero Power, there is the mark Hero Power, and then there's also the mark that it licenses to its joint venture partner, Midwest Hero. Then on the right side, in the right column, the word mark used by the defendant is Wind Hero. Then there are logos involved. On the left is the Hero Power logo with the blue image of the blades of the wind turbine. And on the right side is the logo of Wind Hero, and you can see that they, possibly recklessly, have adopted a logo that has very much the same color and has one word that is the same. I won't comment yet on where I think this comes out. I'll let those dealing with the district court and ITC address that in more detail. But I think that's an unfortunate selection, and I would not have advised Wind Hero to go that close to what Hero Power is doing. Then the trade dress is at the bottom. In this case, on the left side, Hero Power thinks it has a unique identifier, source identifier. Its blades are blue, sky blue. It has a white tower, but the blades are sky blue. Now you may think that creates certain issues for planes flying low and for others, but marketing people at Hero Power thought that would be a great way to identify this as a wind turbine that comes from Hero Power. And of course they don't think that's functional. You note how it just blends into the sky background. If it's functional, it's not protectable, as I'll tell you in a minute. So they say it's not functional. They will say that that is something that's a source identifier and it doesn't perform any function other than acting as a source identifier. Then on the right side, you can see the colors that were adopted by Wind Hero for their turbine. And there, it's not just the blades of the turbine, but the entire assembly, including the tower, is sky blue. And they probably would make the argument, well, that's clearly functional. We want the whole thing to blend into the sky, not to be such an eyesore. So that's why we selected this sky blue. It has nothing to do with the fact that Hero Power has sky blue blades for its wind turbines. So one of the focuses in this litigation will be on whether or not there is protectable trade dress. I listed up here the 3 things that have to be shown to determine whether something is or is not trade dress. First, the trade dress must not be functional. For example, there mustn't be some engineering reason or some other reason that is functional as to why that color, in this case, was selected to be used on the blades. You'll hear from Nick a little later that if you have a registration for your trade dress, you don't have to prove that your alleged trade dress is non-functional. It's up to the defendant in that case to prove that it is in fact functional. So there's an advantage if you have a registration. Secondly, it has to be distinctive, which means it has to be recognized as a trademark. Now, if we were dealing with packaging for trade dress, it would be enough to say, well, this is a really inherently distinctive packaging that doesn't look like anything else, and people are going to recognize it right away as a trademark. But in the United States, when you're dealing with something that is not the packaging, but the design of the product itself, the product configuration, then you have to show that there's been sufficient sale and marketing of the product to help consumers understand that it functions as a trademark, to show that there's secondary meaning in that trademark. And the Supreme Court in the US has said that if there's doubt as to whether or not the product is the packaging, and here you might argue, well, it's the color, it's kind of the packaging for it. If there's doubt as to whether or not it's the packaging or the product itself, the court will tell you to assume that it's the product itself, which means there's a higher standard to show that there's secondary meaning in it. And then you have to show that there's a likelihood of confusion, just as you would in any other trademark case. In this case, though, a likelihood of confusion between the 2 wind turbines and particularly the blades that are used by the 2 companies. Another issue in this case, if you read the materials, is that there is a license from Hero Power to a company in the Midwest to use the term, in a joint venture, to use the term Midwest Power. So that will really raise other issues that would be focused on in litigation. In the United States, if you license a trademark, you have to show that the owner of the trademark has exercised control over the quality of the goods that are being provided by the licensee. In this case, Hero Power has to be exercising control over the quality of the goods that are being sold, the turbines and the blades that are being sold by its joint venture partner. If you can't show that sufficient quality has been exercised, then a court could find that there was what is called in the US a naked license, which means that the licensor, the trademark owner, and the plaintiff has lost the right to exclude others from using that term because they failed to exercise quality control. And that goes back to that principle I mentioned earlier on, that one of the points of a trademark is that it stands as a sign that there's a consistent level of quality. And if that quality hasn't been exercised, then courts will tell the licensor, you've lost the right to claim exclusive rights in that trademark because of a naked license. So this is another one of the issues that likely would be focused on in discovery, whether it's in federal court or whether it's in the International Trade Commission. So with that background of the trademark issues that are presented here in basics on trademark law, I'll turn it over to Nick, who will talk about first Customs and Border Protection and then also about litigating this dispute in a federal district court in the United States.
Thanks, Dave. I'm going to take the principles that Dave just discussed and as he said, try to apply them to enforcement efforts both before the United States Customs Office as well as federal district court. Back in 1990, Customs established the Intellectual Property Rights Branch, IPR, and one of its main jobs is to go out and aid customs officials, customs agents in identifying products and marks that may be used in violation of trademark owners' rights and enforcing those rights. And there's a few ways that they enforce. They can either exclude completely, detain, seize, and if you get to that point, ultimately there's usually destruction of the product. There are a few requirements that you have to meet before you get to the point of customs enforcement. The first one is something that I'm gonna reiterate throughout this presentation, and that's you have to register your marks. Dave's right. In the U.S., mark rights arise from use, but there are several benefits that come from registration, several benefits relating to enforcement that comes from registration. And in the context of customs, you have to register your mark with the Patent and Trademark Office on the principal register before you can even take the step for enforcement. So here, the marks we'd look at registering would be, again, the word marks, Hero Power, Midwest Hero. Those are probably some relatively easy registrations to get through. The Hero Power logo as well, we'd want to register. The more difficult registration would be the color blue in connection with the wind turbine, the blades, the blade, and the pole, however we're going to define it. In my opinion, the best way to define the trademark would be the blades themselves used in connection with the color blue. Ideally, we're not making a product configuration sort of claim here. We're not claiming the blades, but we're claiming the color blue, and we carve out the blades as not being something that we're trying to protect, but just color blue in connection with the blades. So once you get your mark registered, the second step for enforcement is recordation with customs. This is a very easy process. Literally, you take your registration, you present it to customs, you provide them with certain information relating to Hero Power as the owner, any companies that are authorized to import into the country the various products. That would be logically the Spanish and Malaysian manufacturers, any importers, any distributors who would have a right to distribute the products within the U.S. And this gives customs an idea of what products are genuine, where they should be coming from, and who they should be going through to. Those are the two requirements to get customs protection. Another option, not a requirement, but definitely something which should be taken advantage of, is the application process. And that's when Hero Power, the owner of the mark, actually interacts with customs, calls them up based on information they have, and identifies to them ports of entry where they suspect infringing or counterfeit goods are coming from, particular manufacturers, particular importers or exporters. And this is just another step that customs can run with in enforcing your rights. What they do then is they look for product coming in, and anything that they deem to be have a reasonable suspicion of violating somebody's rights, they will detain the products. And there's three bases upon which customs will detain the products. The first, if the goods are counterfeit. The second, or if the goods are bearing a mark that is confusingly similar to the registered recorded mark. And the third is if the products constitute gray market goods. Now, both the Lanham Act and the Tariff Act give customs the authority to seize and forfeit any imported goods that are bearing counterfeit marks. So the question becomes, what is a counterfeit mark? Well, counterfeit mark is a mark that's spurious. That means it's false, it's not genuine, and a mark that's identical to or substantially indistinguishable from a mark that's been registered with the USPTO and recorded with customs. Once the customs officials identify a product as bearing a counterfeit mark, they will notify the trademark owner, they will notify the importer, the bad guy, so to speak, and there's certain steps that they can take within a 30-day window, which I won't go into detail on here. But that's, you've got the point of seizure there. And ultimately, if the products are found to be counterfeit, the customs will, in all likelihood, destroy them. In addition, relating to counterfeit products, people involved, the defendants involved, are subject to civil fines equal to the the MSRP for the first violation, and any subsequent violations, the MSRP, twice MSRP for the genuine goods. So the best case here, again, looking at this for a counterfeit seizure, looking back at the standard, the mark has to be either identical to or substantially indistinguishable from. Again, in my opinion, the best case here would be the use of the color blue in connection with the wind turbine blades. Those are the marks that appear to be the most identical, the most substantially indistinguishable. The other marks, the logo marks, yes, they're close, but there's some variations which I think would take them outside the scope of that standard. They're word marks as well, although closer. They're not necessarily substantially identical as customs would view it. The next basis for enforcement would be confusingly similar goods. Now, these are goods that bear a mark that's likely to cause confusion, mistake, deception with respect to the genuine goods. And this goes back to the standard that Dave was talking about on confusion, likelihood of confusion. Customs looks at two of the elements that Dave identified in making a determination whether the product or the marks are confusingly similar. And those are the two main elements probably in any infringement analysis, and that is the similarity of the marks and the similarity of the goods. Well, obviously here we have identical goods, so that issue is off the table. The next issue then becomes how similar are the marks. Here I think you can make a pretty good case based on all the marks that we have that there's enough similarity here that customs would take that next step and detain product that bear these marks. Let's, for instance, look at the word marks, Hero Power and Midwest Hero. Well, these both have two elements, and the elements are different from the Wind Hero mark, but they do have an element in common, and that is hero. In my opinion, hero is the strongest element of the mark. It's at least suggestive in the scheme of it's not descriptive, it's at least suggestive, if not more. And the other elements, power, Midwest, wind, these are all descriptive terms, so they don't really give any protection for the mark. So again, CBP, once they seize products based on confusing similarity, they send out notices to both the owner of the marks and the importer. And the efforts that can be taken to overcome the seizure, the importer can obtain the consent of the trademark owner, or they can obliterate the marks from the product, which would be just that. You take off any indication of the marks. And the final basis for seizure is gray market goods. These are a little bit different. These really don't play into our fact pattern here, but I'll mention them. Gray market good is a good that's manufactured with the authorization of the trademark owner. They bear the genuine marks, but they're not authorized for distribution in U.S. commerce. These can be manufactured in the U.S. and sent to foreign markets. It can be manufactured in foreign markets and intended for sale only exclusively in foreign markets. So if there's a product that is not intended for importation or distribution in the foreign market, customs will seize those products as well. Same relief is available for the importer, either complete obliteration or destruction of the mark from the product itself, or obtaining consent from the trademark owner. Again, on the fact patterns, I don't think we have a real good claim for gray market goods here. Moving now from customs to federal district court. A lot of these causes of action are going to sound similar to what we talked about in customs and also what Dave talked about earlier. The first cause of action that I want to talk about is trademark infringement or trade dress infringement under Section 32 of the Lanham Act. Now, this applies to marks that's used in connection with the advertising, sale, offer for sale, distribution of goods which are likely to cause confusion, mistake, or deception with respect to goods bearing a genuine trademark. Again, going back to some of the elements that Dave talked about earlier, when you're trying to establish likelihood of confusion, the courts, and they vary by jurisdiction, will look to several elements to determine whether confusion exists. one of the elements is similarity of the marks. Well, we've talked about that a little bit here. I think you got a pretty good case with respect to the trade dress, the logos as well. You've got the same color scheme. You've got the distinctive element hero that's really prevalent in the marks, and the other elements are less prevalent, the descriptive elements. So you've got a pretty good case, in my opinion, for a similar mark here. The goods here are similar as well. They're identical, in fact. You've got to look at the similarity of the channels of trade and advertising. Here, this would be in Hero Power's favor. They're identical. Evidence of actual confusion. It's great to have as a plaintiff in a trademark infringement case. It's not necessary. Here, Wind Hero's entry in the market is relatively recent, so you wouldn't necessarily expect there to be evidence of actual confusion. It can be a point which would either weigh in favor of Wind Hero or just sort of be a wash since it is so early. Consumer sophistication was another one Dave mentioned. Now this is important in this case in that the consumers that are purchasing and making purchase decisions for these products are going to be extremely sophisticated. They're going to be knowledgeable about the products, knowledgeable about the field. They're not going to be easily deceived by slight variations in marks. So this would be a factor that would weigh against Hero Power and in favor of Win Hero under the facts. The overall strength of Hero Power's marks, well, this could go either way. What you do here is you look at the inherent distinctiveness of the marks. As Dave mentioned, there really isn't going to be, well, it depends, I guess, how we define the trade dress, but if we're talking about the product configuration, we're not going to have an inherent distinctiveness. You're going to have to show distinctiveness through secondary meaning. The hero marks, although suggestive, hero is a relatively commonly used term, a commonly used mark, most likely in connection with other businesses. So you'd have to look at all that to see how this element would come down. And finally, you'd have to look at Win Hero's intent in adopting the mark. Here, ideally, this would be a good case for asserting all of Hero Power's marks. I think, in my opinion, it would be a pretty good case, subject to some of the defenses we're going to talk about later. But just on its face, if you look at the likelihood of confusion elements, you have a pretty strong case here. Unfair competition. Let me just back up, and if I didn't stress enough, the key for trademark infringement under Section 32 is that the mark has to be registered. So again, just stressing the importance of registration. You would need to have registrations for all of these marks. Moving now to unfair competition. Similar to trademark infringement, the marks to assert an unfair competition claim do not have to be registered. They can be common law rights. And this looks for marks or false designation of origin, false or misleading description of fact that when used would cause confusion and confuse consumers into believing that Win Hero's products are somehow sponsored by, authorized by Win Power. And there's several factors, again, that are looked at in determining whether unfair competition is available. The first would be the protectability of the mark. And this gets back to the issue of distinctiveness and functionality. Without registrations, it would be Hero Power's burden to show that the mark is distinctive and to show that the mark is non-functional. If you have these registrations in place, that would be on Win Hero's. The burden would be on Win Hero to show non-distinctiveness as well as functionality. So again, registration becomes very important in this context, although it's not necessary to bring an unfair competition claim. You also have to show that Win Hero's use would be likely to cause confusion. This is the same standard that we see in the context of infringement. So the same standard being applicable, I would assume that the unfair competition case would come out pretty much along the lines of the trademark infringement claims. Again, the distinction being whether or not the marks are registered and the burdens of proof that result from that. The next cause of action is trademark counterfeiting. Again, we looked at this in the context of U.S. Customs. You get a little bit more mileage out of a counterfeiting claim at the U.S. District Court simply because the remedies are relatively harsh compared to what you will get in the context of a straight trademark infringement claim. Some of the elements for making out a counterfeit claim at the district court level. Again, the marks must be registered on the principal register. We see it again, the importance of registering your mark. You have to have registrations to bring a counterfeit claim. Hero Power's mark must be in use. Of course, it is here. Again, we have to show that Win Hero's mark is spurious, that's false, non-genuine, and it's either identical to or substantially indistinguishable from the marks of Hero Power. You have to show that the marks are being used in connection with the same goods as those for which Hero Power has a registration. Not a problem here. And you have to again show that the marks are likely to cause confusion. Now, in the context of counterfeiting, this is assumed once you make out the other elements. Once you make out the other elements, the mark itself is counterfeit, then confusion is inherent. Again, like with the customs analysis, in my opinion, the best case here would be the trade dress, simply because that's where we have the either identical or substantially indistinguishable marks. A couple more causes of action which I'll touch upon, although I don't think these are particularly good case for these causes. The first is dilution. Now, dilution, as Dave mentioned, allows the owner of a famous mark to enjoin others from using a mark, regardless of whether there's competition, regardless of whether there's confusion. But prior to obtaining relief, you've got to show the mark is famous, and you have to show that it was famous as of the time the defendant entered the market. Definition for fame: to be famous, a mark has to be widely recognized by the general consuming public of the United States as a designation of source of the goods of the mark's owner. So it's widely recognized among the general population. When dilution law was first being formed, some courts were recognizing niche fame. In other words, if Hero Power were to establish this general knowledge among the wind turbine or alternative fuel source population, it may be sufficient to show fame. Not anymore. Now you've got to show a general fame. It's a much higher burden, a much higher standard. And absent additional evidence suggesting that this mark is famous, you know, I don't know that a dilution claim would be advisable. Now you can go out, you can do consumer studies to determine whether or not the mark is famous, and it's probably something you'd want to consider doing before proceeding. And the last federal claim I'll talk about is a false advertising. This is sort of a subset of unfair competition. Allows for claims for statements which are in commercial advertising, false, misleading, either with respect to the plaintiff and the plaintiff's products, or with respect to the defendant and the defendant's products. These statements can be literally false, they can be impliedly false. You've got to show that the statements are material and that the consumers made a purchasing decision based on the statement. You've got to show that the misrepresentation actually deceive or have a tendency to deceive a large segment of the population. And there's some other factors as well. Again, based on the information we have, it doesn't necessarily look like this would be a good false advertising case. What you'd want to do is you'd go out and review Win Hero's advertisements, review any trade publications, any news releases, press releases that they've had, to see if there's any basis for making these claims. So those are the federal claims in a nutshell. I just should mention that in addition to federal claims, there's a variety of state and common law claims that have to be considered before you bring any action. A lot of states have claims that mirror the federal claims, and they're either statutory, mostly statutory, some common law, infringement, dilution, misappropriation, trade secret misappropriation. Also, there's some related claims such as consumer fraud, deceptive business practices, tortious interference, those kinds of things, which you would tack onto the federal claims, so to speak. Now moving on to the defenses, and really I think this is just going to be rehashing what Dave has talked about and what I've talked about. There's a few defenses available under some of these causes of action that we've discussed. The first defense would be that the mark is not protectable. It's not inherently distinctive. Or I'm sorry, it's not distinctive. As Dave mentions, a mark can either be inherently distinctive or be shown to be distinctive through years of use. If you've got a registration, again, for these marks, distinctiveness is presumed. If you don't, as the plaintiff, you've got to show. You'd have to look at advertising, sales, all kinds of information like that would give an indication of how broadly known the marks are. Again, looking at the hero power word marks and logo marks, I think you've got a pretty good argument that these marks are at least suggestive, and I think you win on the distinctiveness element. The trade dress element, it would be a little bit more difficult. Again, I'd rather be in the position of being a plaintiff with a registration and having that presumption as opposed to having to show it during litigation. Functionality also would be a huge issue in this case. There's a couple tests for functionality. One is whether the mark is essential to the use or purpose of the article or affects the cost or quality of the article. That's a more recent standard. Another standard which is used is whether the exclusive use of the particular product would put competitors at a significant non-reputational disadvantage. Well, looking at the functionality claims with respect to the trade dress, the color blue, is it essential to the use or purpose of the article, or does it affect the cost or quality of the article? I would highly suspect that it does not affect the cost or quality of the article. Maybe there's some arguments that would suggest otherwise, but I think you're okay on that point. Essential to the use or purpose of the article, well, if we're talking about the functional purpose of wind turbines, the color blue has absolutely no bearing on it. Where I think you may get caught up here is if the exclusive use would put competitors at a significant non-reputational disadvantage. Here, arguably, Wind Hero would proffer, look, you guys are out there, you've got the sky blue turbines that enables you to blend into the sky. This is what consumers want. And by not allowing Wind Hero to make use of the same color, you would put them at a significant non-reputational disadvantage. In other words, purchasers would be making the decision in large part based on their ability to use the color by themselves. So that is where I see it sort of coming down on the functionality. And finally, again, as Dave referred to, naked licensing. We want to make sure that not only the license, the written license itself has stringent quality control provisions, but there's control, in fact, being exercised over any licensees. And this could be Midwest Hero, any of their manufacturing or distribution, any of their advertisings that are making use of the mark. You'd want to review those and make sure that the marks are being used properly and that the goods meet the standard of quality that Hero Power sets. Also, in offshores manufacturing, anytime that the marks are going to be used and come in to the United States, you'd want to make sure, from a U.S. perspective, that the marks were being used consistently in accordance with quality control provisions. Moving now briefly to damages, available damages under some of the claims that we've talked about. For trademark infringement, unfair competition, false advertising, the damages are all the same. You're entitled first to injunctive relief. This can be in the form of preliminary or permanent injunctive relief, which would preclude Wind Hero from using the marks. There's also various monetary relief available. The first would be disgorgement of Wind Hero's profits. Any profits that Wind Hero makes from the sale of infringing product could be taken and given to Hero Power. You can also elect damages in lieu of profits. This would be Hero Power's lost profits. In some circumstances, the court can enhance those damages up to 3 times the actual lost profits. This isn't designed to constitute a penalty, but instead, it's viewed as a compensation where the lost profits may, for one reason or another, not meet that standard. Also, attorney's attorney's fees can be given in exceptional cases, and prejudgment interest discretionary with the court. Dilution, also you've got injunctive relief as a remedy. You've got the other monetary remedies I just discussed in connection with infringement, but those will only be granted in dilution context if dilution is shown to be willful. And finally, trademark counterfeiting. I mentioned earlier that this is one that actually has some teeth, a little bit more than your run-of-the-mill trademark infringement claim. First, a very effective tool for counterfeiting is the ability to obtain an ex parte seizure order. This would allow Hero Power to go into court and upon actually a pretty stringent showing, obtain an order that would allow them to go in to Win Hero's facilities, any facilities of its distributors, with the U.S. Marshal, and actually seize counterfeit products. And being ex parte, this is done without giving any notice to Win Hero. Again, there are several elements that are designed as safeguards that have to be met in order to get such an extreme remedy. It's difficult to get. In my opinion, given the presumably good reputation, business reputation of Win Hero, it'd be difficult to get this. A lot of times it's saved for your fly-by-night importers, exporters, people who may disappear easily, which actually is one of the elements you have to show. Another available remedy is monetary in nature. It's mandatory treble profits or damages, whichever is greater, and reasonable attorney's fees. So mandatory, the court has to issue treble profits and damages. That's pretty impressive. The only time it doesn't, if there's extenuating circumstances. These are extremely rare. The legislative history, I believe, talked about a circumstance where an individual wouldn't be able to support their family as a result of the judgment. So the extenuating circumstances are not common at all. And finally, after proving counterfeiting, there's an option for statutory damages. And this will range from $1,000 to $200,000 per counterfeit mark per good, and that's if it's non-willful. If it's willful, it's up to $2 million per mark per type of counterfeit good. So again, some pretty significant remedies there. And finally, I'm briefly going to touch upon some issues regarding forum selection and procedural considerations in general. The first thing you got to look at, obviously, is personal jurisdiction. You want to make sure the forum you're bringing the claims in will have personal jurisdiction over all the defendants. You don't want to get caught up in these early motions to dismiss or transfer based on lack of personal jurisdiction or improper venue. It gets expensive, and it really bogs down the litigation. Subject matter jurisdiction is the next thing you need to look at. Obviously, we've got federal claims here. The court has original jurisdiction over all of them, as well as supplemental jurisdiction over the related state law claims, so that's not an issue. You want to do your due diligence and research in looking at the substantive laws of the various jurisdictions, the various circuits. You want to look at the elements of proof needed for each claim in each circuit, how the courts come out on close cases of trade dress infringement or whatnot, whatever the specific issue is. But ideally, you have a jurisdiction where you have the most favorable law. You've got personal jurisdiction over the defendants to bring your claim, and you also want to look at the local rules of the individual district court and the practice there to see which best fits the facts. And finally, I'll just mention, especially considering that Hero Power is a Middle Eastern company, Egyptian-based company, there's several juror-type considerations that you should be looking at. You may not want to have an Egyptian defendant, an Egyptian plaintiff in front of a Texas juror, for instance. And finally, I'll look at some of the cost considerations. It's litigation. It's U.S. litigation. That inherently means it's expensive. can range anywhere from about $1.5 million, $2 million, $3 million, depending on the complexity of the litigation. And the cost really can be driven up by a couple of things. One is the use of experts. Experts are used quite often in trademark cases. They're used to show distinctiveness. They're used to show functionality or non-functionality. If you've got a dilution claim, they may be used to show fame. Damages experts are often used. And with the use of experts comes much higher fees. And the other thing to look at is discovery costs. Again, full-blown discovery, written discovery, exchange of documents, depositions, usually of several witnesses, and depending on the complexity of the case, these costs can be significant as well. So that's pretty much all I have on customs and district court enforcement. Again, if there's one thing that you take away from it, it's the importance of registering your mark so that you can have available to you the full gamut of enforcement efforts. And with that, I'll turn it over to Carl.
And just, the board has just a couple of questions, quick questions before we transition to Carl. One question that came up, Nick, is because of the expense of federal district court litigation, can we try to stop these products through customs first, and if we're not successful, go to the district court? Yeah,
absolutely, and that would be, the recommendation. It's a much more efficient way to prevent entry of these products into the market. And my guess would be that would be successful for a while, although I think you would get to a point where, given the investment that Win Hero has, it would get elevated to the next level, whether that be at the ITC level or a district court action.
Okay, so thank you. Now, Carl, we're also interested in possibly bringing an ITC action because we understand that may be quicker than in district court. Could you advise the board on how that works?
Oh, sure. Actually, Laura, it wasn't the way I was going to begin.
But whatever way.
But I was thinking here as Dave and Nick were talking. What is it that I wanted to say? I mean, this is sort of a preamble. I think that'll pay some dividends. And it sounds strange. I put together 20 slides, and I went to bed last night thinking, well, logically they're connected, but what is it that I want to say? And it was when Dave was talking, and by the way, they got the issues with the real good sex appeal. I got the International Trade Commission. But what I want to bring to your attention is the fact that the International Trade Commission exists, and it could be a great weapon if used effectively, and it could cut you off at the knees if used effectively against you. If you were to appear at the International Trade Commission as a complainant or a respondent, the legal principles that Dave set out would be essentially the same. The litigation strategy that Nick set out would be essentially the same. So, in the facts of this case, and I had a slide for essential facts, and there were relatively few. The only facts that concern me are: one, is there an importation of a product, wind turbines, into the United States? And two, is there a domestic industry? Everything else we could work around, but for ITC jurisdiction, ITC concerns, that's what's really important. And why is the ITC, and by the way, I'll get you out on time, guaranteed. But why is the ITC important to you? It's important to you because if you prevail against a competitor who is infringing your trademark or infringing your trade dress, you can exclude the infringing products from entry into the United States. It's important, again, as I said, if in the future that you find yourself on the other side of the ledger and someone comes knocking on your door and serves you with a complaint, that you're in a position where you're importing your wind turbines from Brazil, And maybe a competitor is going to claim that you're infringing on their trademark. And if they prevail, you're out of business. This seems small, but it's important. It's where I used to work, but that's not why it's there. This is the U.S. International Trade Commission. There are 6 commissioners and 6 administrative law judges. It's important in the sense that you know where the action's occurring. It all occurs within that one building. And this slide is essentially, it's taken off of the ITC's website, and it defines their mission. And what they say is, we're involved in intellectual property. Our mandate is the Tariff Act of 1930 as amended. What we can do for you is to issue exclusion orders and cease and desist orders. And by the way, all proceedings at the ITC are governed by the Administrative Procedure Act. The ITC is known as being quasi-judicial. Take out the quasi. When you're involved in an ITC proceedings, and the ITC, while the vast bulk of its work is in the patent law area, there's certainly trademark cases that it hears. You're going to get the best and the brightest lawyers. You're going to get the top law firms. You're going to have litigation teams. You're talking, again, district court, maybe even more level of cost. 5 years ago, it was $3 to $5 million to try a typical patent case. I believe trademark cases may not be as involved, but I don't think it's going to be too much cheaper. So that's another good reason why you should know about the ITC, because if you find yourself there, it's going to be a very, very costly venture. The ITC, and I'm going to go ahead and move things around here. At the ITC, the action begins with the complaint. If you're interested in pursuing this matter, you'll file a complaint with the ITC. They have 30 days upon which to institute an investigation. During that 30-day period, there will be attorneys within the ITC that will help you, that will review the substance of the complaint, make sure it's procedurally sound. And at the end of the 30 days, if you jump through the hoops that these commission attorneys tell you to jump through, the complaint will be instituted. And a notice of investigation is issued. And to show the scope of a notice of investigation, this was a case that I heard. It involved Qi hair irons. And if any women in the audience, if you have a Qi hair dryer, you know it's there on top of the line. If you purchased it online, you know, don't get your hopes up. The Qi hair dryers can be purchased at JCPenney selected salons, but you could go online today and pretty much find them everywhere. And what's interesting about this notice of institution, and this is the ITC telling the world, the game is on. Farouk Industries in Houston, Texas is bringing an action against Qi Systems out of Singapore, Princess Silk out of California, Kamashi International out of Hong Kong, Mount Rise out of China, and Duangong out of China. So the breadth of an ITC investigation are going to be to all 4 corners of the globe. So after the notice of investigation is instituted, the matter is assigned to a judge. And at that point, you're going to have your typical litigation that you're going to have in district court. You're going to have discovery. It's going to be very costly. You're going to have depositions all around the world. It's going to be very costly. You're going to have your motions practice. And then the judge is going to issue a decision. Yes?
Just a quick question. A lot of us are representing foreign governments here. We're trying to get product into the U.S. How can we use the International Trade Commission on behalf of our constituents in foreign countries coming into the U.S.? We're doing the reverse, kinda.
Okay. Well, I don't understand your question.
Oh, well,
I'm sorry.
we represent like the government of Italy,
Right.
the government of Austria, whatever. And we have Austrian, Italian, German,
Mhm.
Australian, whatever, wanting to come into the States with their products or machinery.
Don't infringe. You pretty much can import what, everything you want as long as you don't infringe. But is your question
How can we use the ITC? to
in your
help?
favor?
Yeah.
Well, that's what I think Hero Power is trying to do. I mean, look,
An Egyptian company.
it's an Egyptian company. The goods are manufactured in Brazil, and its attempt to create a domestic industry in the United States is tied to Midwest Hero. And I do have a slide, but I'm not going to waste time running to it. Section 337 is the key section in the Trade Act of 1930 that you'd be interested in. Section 337A1A would allow you to bring an action for trade dress infringement. Section 337A1C specifically will allow you to bring an action for infringement of the Lanham Act. And addressing your question, in order to bring an action under Section 337A1C, you have to have a domestic industry, and that's set forth in Section A3.
Who's the
A
domestic partner?
No, a domestic industry, and that's where you're going to have the opposing law firms trying to rip apart your case. But you can establish a domestic industry through a significant investment in plant and equipment. So if you want to build a plant here and you want to establish domestic industry in a case, you'll put on a company witness to show how many employees you've hired, how long they were hired, what they're being paid, what are their duties, and tying in their duties specifically with the article you want to be protected, whatever you're importing from Italy. Another way in which to establish the domestic industry, which you really need, you don't have it, you're out, would be a significant employment of labor or capital, or a substantial investment in the exploitation, including engineering, research and development, and licensing. So you have three ways in which you can establish domestic industry. And the International Trade Commission over the years, when I first started at the ITC, pretty much anyone can establish domestic industry. I had a case in which a United States manufacturer, which had been on the cutting edge of developing assembly line tools, pneumatic tools that can be detached without slowing down the assembly line production, had their sole function in domestic industry. They received the product that was manufactured in China. It was sent to the United States. They did some research and development. They packaged that product, those parts, in a plastic bag, then sent them off to Mexico for assembly. But yet they were found to have domestic industry. Times were changing. I don't know for whatever reason, but the Commission case law has shown that the Commission is really tightening up on the domestic industry issue. It's not as easy to establish a domestic industry, and it can be done, but the Commission is looking more closely into those issues. So as a foreign owner of U.S. intellectual property rights, as long as you can establish that key domestic industry, then you've taken a huge step forward. But as I said, it's not so easily done now as it has been in the past. And the ITC, as I said, is very important because you can get justice fairly quickly. In a trademark case, from the time that the complaint is instituted, we saw the notice of investigation to the time that the judge issues his decision, 1 year. On appeal to the Commission, 4 months. On appeal to the Federal Circuit, a year and change. Now, compared to patent litigation, that's warp speed. I don't think it's warp speed compared to trademark litigation, but I think it's faster. So not only does the commission have just a huge club to wield on your behalf, it can be done so in a fairly, you know, at a fairly fast pace. Also, too, another factor that you might want to take the commission in mind is that you only need in rem jurisdiction. If you, in this case, for example, it's interesting that the defendant or the respondent is a U.S. Company, but if you're importing, what do you want to import? I mean, some fictitious. Okay, if you wanted to import wind turbines from Italy, okay. You wouldn't have to have personal jurisdiction over the respondent. You have jurisdiction over the product. In fact, if the party that you went against defaulted, I think you'd have a much easier time gathering the information to get a general exclusion order or a limited exclusion order. The key word here is exclusion order. You're keeping out competitors' goods, but competitors' goods that you believe are infringing on an intellectual property right that you own. They're all the key points that I wanted to hit in sort of like in the 3-minute drill during the halftime of the football game. So I guess now I said I'd get us out here on time, so we'll do questions.
Does anyone have any questions?
Yeah. Going back to the earlier question, in your opinion, obviously it depends on the facts, but the joint venture with Midwest Power, does that affect the domestic industry?
Yeah, that hurts. I mean, I'd have to know more facts, and the reason it hurts is you know it's a tender point, and that's where your opponent's going to strike. So before you go spending a lot of money on legal fees, you're going to make sure that you have a good argument, that you know all of the facts. I've seen joint venture companies at the ITC, but mostly in the role of the defendant. Typically, when you have foreign ownership of U.S. intellectual property rights, there will be an American technology company. It'll be wholly owned by the foreign corporation. So they have some solid footing. And then the question is, well, are they a real domestic base, or are they just this veneer of a domestic base? Are they, is the foreign corporation really spending the capital, making an investment in the brick and mortar, making an investment in the research and development? So I mean, that is a little bit of a tender point. And along those lines too, here we have Midwest Hero engaging in research and development. You'd really have to know more specifics. I mean, who's involved? Are there engineers? Is it significant work? Is there significant salaries being paid? A lot more facts than we know here.
Yes.
General questions for international companies coming to the US, for instance in Europe. You know, they might have a name, their marks are registered in Europe, and logos and everything. So as I understand, there's no need really to register that individually also in the United States. It's just advisable for custom issues.
I'll take that.
Okay.
It's very advisable for them to register in the United States as well, for all the kinds of advantages that Nick was talking about, things that relief that you can get if you want to be a plaintiff in the U.S. that you can't get if you're only relying on unregistered rights. And typically, multinational companies' trademark portfolios will include registrations in all of the relevant jurisdictions, relevant in the sense that they're markets where they plan to sell product. So registration in the U.S. is important, even for a company that has a well-established mark in Europe or in Asia or South America.
Well, the system would be then an IPR lawyer in Europe would register also here with the United States?
Yes,
Patent office?
that's correct.
So not individual.
Yes, and there are various treaty ways that make it a little easier to, a little less expensive way to get registrations around the world. But the bottom line is that you have to end up with registrations.
On the markets.
Right. And it's common for us, where we have U.S. client companies, to be working with lawyers throughout Europe and in Asia and Africa and South America to register our clients' rights there. And then we also do the same thing for law firms that have clients in Europe and they're registering in the United States because they are going to have significant business here.
Also for the ITC, registered marks give you advantages and lower proof points, so it helps it in that form as well. Yes, sir.
To avoid all this costly litigation, how much would it cost just to hire you? One trademark, one logo,
Yeah, but I'll give you the lawyer's answer. It depends. If it's a simple registration and you're looking at, well, let's talk about the process. The process first usually includes a clearance. And we normally would recommend that there be a clearance, there be a search, so that you don't end up with a surprise in the U.S. before you come into this market. And by the way, you probably, at the time your client or your company that you're looking at is adopting a mark in Europe, say they're in Europe, if they are thinking ahead to the fact they're going to be in the U.S., they're probably at that time doing searches in other countries as well. So in the U.S., for a search, you'd be looking at probably $1,500 roughly for one mark. That's the cost of the time to look at a search report and ordering a search report. That's just for the U.S. And then if you're looking at the registration process, you're probably looking at something in the $1,000 to $1,500 range, depending on the number of classes that are included. And that's just for filing the application in the United States. Then, as the application is prosecuted in the trademark office, there may be questions raised by the office, and we call those office actions, an action by the office raising an issue. So there might be additional fees involved in responding to those kinds of questions.
do they expire? You have to renew them every
Yes, they
year?
do. They expire after 10 years. You have to renew them. It's similar to the registration process in other countries in the sense that they expire and they have to be renewed to avoid expiration. And if you want to keep your priority date in place, you need to make sure that you renew before you've had an expiration in order to keep whatever advantage you got from that first filing in the United States.
All right, a question for Nick about the general population awareness of something. You mentioned earlier that general awareness of the thing is confined to just those that are familiar with the industry. But now you see that the more trend going to the larger audience that may not be as familiar with the industry. What, in your own experience, have you found those of late to be difficult industries which have a hard time having a general audience awareness?
To show.
For example, biotechnology
fame.
or rapid prototyping or something like that.
It's an interesting question. I mean, you can look at an industry like the auto industry, for instance, and that's going to be an industry where if you've got a leader in the industry, it's not going to be surprising if the marks, the brands that those leaders use are relatively famous, Ford, Chevrolet, Nissan, whatever. I guess to answer your question, I mean, the less consumer-oriented industries would probably be the ones that are most difficult to show a general knowledge or understanding about the brand. I can't think of anything specific that comes to mind, but any industry where the purchasers are small, relatively sophisticated, and the marks, the brands aren't shown or out in front of the general public a lot, is going to be a difficult case to make on fame or dilution. Now that statement relates to dilution only. When you're talking about likelihood of confusion, the industry can be, or the relevant public can be defined more narrowly, and it is the relevant consuming public, the people who do make the purchasing decision. But in a straight dilution, since there really is no competitive element necessary, there is no need to show likelihood of confusion. The FAME standard is much more broad.
A way to think of that in terms of whether you're dealing with fame or if you're trying to show strength and recognition of the mark in a secondary meaning context is how you would go about proving that. It usually would be done with some kind of a survey. And as Nick said, if you've got consumer goods where it's widely advertised to a general audience, it's going to be easy to construct a survey that will show recognition of that term. And that makes the point that it's much more difficult where you're dealing with a much smaller audience. You know, just the process of constructing a survey is more difficult because where are you going to find the relevant respondents for a smaller audience? With a regular survey where you're dealing with consumers, the survey experts go to malls. They intercept, they're called mall intercept surveys, or they do telephone surveys or internet surveys that are easy to construct because you don't have to keep looking to find somebody within the very narrow market. So that really makes the point that it's the consumer products industries that are much easier to show widespread recognition and fame than it is with something that's more specific.
Yeah, the reason I ask is because we have machine manufacturers in Italy that have various production lines that have generic names per se, but they're known within their industry for carrying that line, like Donna or Davi or whatever.
Yes.
And that sometimes runs into conflict with consumer products that have names similar but not the same. And so sometimes they've had to go back and change their name, change the name of the production line. But even sometimes the techniques or applications that they use, they've given it a registered trademark for the process we manufacture.
Right.
And there's been conflict with other foreign manufacturers or domestic manufacturers because that name's been used by somebody else, like a seamless technology.
Yeah. A common example of that kind of problem is where a company's products are sold as OEMs, original equipment manufacturer products. Something will be incorporated in another product that consumers don't usually see. Mm-hmm. So when you're dealing with infringement, you're going to be dealing with the purchasers who are going to make the decisions about whether to use those components in a product that the consumer will see. That's why Intel, for example, runs an ad campaign that says Intel inside. Or at least the whole idea is there is a component in that computer, but they're trying to build awareness among the public of that component that normally a consumer would never see or think about.
Any other questions from our board members? Yes.
I have a question about current day domain name sensitivity, so to speak. A couple of years ago, I was a real-life board member of a high-tech IT company back in Hungary, and we were in the process of selling our company to an American company. And we considered one of our little assets, part of the values of the company, that are set of registered domain names. We are talking about Hungary.hu. And we had a domain name, and it said ya.hu, which ya.hu. So that's
Yahoo.
And
I have to say that Yahoo is a client of the firm, and I can't comment on.
Our lawyers advised us not to start portal sites or anything using that. It was ours, but finally the board decided to skip and not to risk any kind of legal issue. So
That was a good move. But that highlights the point that it's the problem all the time. The selection of the domain name often is really important to the online presence that a company has. And when you're looking at, part of the clearance and search process I talked about also includes looking at domain names early on.
It is sensitive.
Very.
Can you take, like, a while ago, Southwest.com was a heating and refrigeration company in California, and finally Southwest Airlines did this. Yeah. But can you tell somebody to give it up? It's a real...
Well, there are, with domain names, there are
So
a few.
can we just repeat the question,
Oh,
just
yes,
so this
sorry.
side of the audience
Yeah,
can hear?
the question about that was, this example was Southwest.com, and Southwest Airlines recently, was able to purchase the rights to southwest.com, the domain name, and the question was there or is there a way for the airline to have prevented southwest.com from having that registration? And there are at least two ways to look at that, at least if you're in the United States. One is you could bring a trademark infringement action over the use of Southwest. You'd have all the kinds of issues we talked about, and Southwest, the airline, would have to show priority, that the owner of Southwest.com didn't have the right to use it because they had inferior rights. You'd have to show likelihood of confusion, all those kinds of issues. There's also a statute for domain names, and what you have to show for that basically is that the registration of the domain name was secured through bad faith, that they had no pre-existing rights, that they have basically what they usually are focusing on are cyber squatters who buy up lots of names without any intention to use the name for business purposes and really just to hold up the owner of a trademark. But here, I think Southwest, the company that owns Southwest.com, was out there before, and they had their own rights in the name Southwest. Something related to that statute is also an administrative proceeding under the auspices of ICANN. We call it a UDRP proceeding, Uniform Dispute Resolution Procedure. I think that's what that stands for. And it's similar factors to the statutory action to show that the domain name was registered in bad faith. If you can show that, you can require the transfer or cancellation of that domain name. But that's a situation where Southwest Airlines would not have been able to do that because there was prior use and prior rights in that term Southwest.
Any other questions? Okay, our panel members will be here after we conclude, and I think Franz wanted to, did you have any announcements or?
No, it's just really in the name of all the trade commissioners, CITCA, Chicago International Trade Commissioners Association. Thank you, Paula, your colleagues so much for this very impressive, interesting presentation. Your English shows the competence your firm has in this field. And we hope that we can draw on your expertise also in the future when we have real cases that we might want to bring forward. For CITCA, October 26th will be the next event about the manufacturing industry in the United States, and also a preview about IMDS 2012. I think a very interesting topic. You already have received the invites. Please join us on October 26th, Austrian National Day. Thank you.
Good.
Okay.
Thank you.
Thanks, everyone.
Thanks, everyone.